case is State versus Norvet, and same rules apply. You have 15 minutes, and you may reserve up to 5 in the state district.
One moment, Your Honors, as I
You're fine.
change my mode of thinking here.
You may proceed.
Thank you. And may it please the court. Mr. Prosecutor, again, I'm Chris Ockerly. I represent the appellant in this matter, Mr. James Norvet. I'd like to reserve, again, 3 minutes if I may,
That's
Your Honor.
fine.
There's only one real issue in this case, Your Honor, and this is whether an Ohio State trooper, when he stops a defendant for a traffic violation and is issuing a warning, does not cite the defendant for any moving violations, he then has the defendant exit his vehicle for a dog sniff. Whether this continued detention after going to issue a warning that's outside the original purpose of the stop is an illegal seizure. In terms of the case that took place, the defendant was charged with illegal transport of a firearm after the facts took it to in a second, and the defendant attempted to suppress the evidence in the trial court. The trial court made a determination that the evidence should not be suppressed, and then the defendant pled to the charge and has been found guilty of illegal transport of a firearm in a motor vehicle. And certainly here's the appeal based on the motion to suppress. Your Honors, on the day in question, the trooper had stopped my client, Mr. Norvet, in the afternoon. He was following too closely to a vehicle, and the officer said that the right side of my client's car went over the fog line, giving him reasonable articulate suspicion to pull him over. We're not challenging the stop today, as you're probably aware. He indicates early on that it was his plan in the testimony, and I cite in my facts again where he says it, but he indicates his plan was to give him a warning. And he decided to do that prior to the second trooper showing up at the scene of the stop. However, instead of that warning, as the second trooper arrives on the scene, instead of working towards issuing that warning, he stops what he's doing, speaks to this second trooper, then walks to the car, has my client exit his vehicle, places him in his trooper's vehicle after doing a pat-down search. The second trooper that arrived showed up and conducted a dog sniff, and that's when the dog alerted to the vehicle. They searched the vehicle and found a firearm locked into the glove compartment, and my client was at that point charged. Of course, this court is aware that the standard of review, this court is supposed to accept the factual findings of the trial court if there's support by some competent, credible evidence, and then apply the facts to the law de novo. Now, the trooper, of course, has a reason to stop my client. The problem with this stop is that I believe the testimony shows that the trooper had run a check and determined that there were no issues with my client's license. And before this second trooper was arriving, made a determination and issue a warning to this person and let him go. And instead of doing the actions that necessary, he changed what he was going to do as soon as the second trooper arrived.
So you're saying, instead of just immediately saying, okay, you can go, after getting basic information, what did he do that was wrong because the other guy arrived?
When the other guy arrived, he after speaking with the trooper, when the other person arrived, he made the determination, well, so I can let you do a dog sniff. Again, this is all after his testimony, I'm gonna let him go.
Now, this is a case where he reached over to the passenger side 2 or 3 times. Am I
Yes, Your
correct?
Honor, and my recollection of the testimony is that the trooper, or excuse me, my client reached over while he was driving twice.
Right.
Yes.
Right. So you're saying that is of no significance to the case that he was, while driving, I don't know if they use the word furtively, but he was doing something that he certainly felt was important enough. And was that before or after he knew the trooper was behind him?
My understanding is I don't know if we know, if my client knew before.
If you can't answer, then.
I don't know the answer to that, but my understanding is the trooper testified after he got behind him. That's when my client made 2, and I believe he uses furtive movements while he's driving, and then as he makes the stop, he again reaches over to the glove compartment area and to the floorboard of the car. So I believe the trooper does testify to those 3 furtive and uses furtive movements.
When you say, you take the position in your brief that because it was in the officer's mind after checking to determine that there were no active warrants, that he would simply give a warning and release your client, is there any testimony in the record that speaks to whether that warning was anticipated to be verbal or written?
I don't believe the testimony. I don't believe the testimony in the transcript shows that he actually said, "I'm going to give you a warning" to the defendant until after some time after the second trooper arrived and he pulled him out and he put him into his car. I think that was where there was some discussion of when that he was going to give a warning.
But my specific question is whether that warning was verbal or written, because it changes the analysis somewhat, doesn't it?
I understand where you're going with this, Your Honor, and I think, and I put some cases that are one's a little bit more important than the other one, two cases that I discussed in there. But you have an officer, a trooper that was pulling someone over and had run the license check or and determined there wasn't any issues, any warrants with the defendant had approached, even after the furtive movements, had approached the vehicle, done kind of a check on the client, asked some questions, and even though indicated that the defendant acted nervously, did not, never testifies as to there was a concern for his safety at that point, or even articulated that there was a concern prior to having my client exit. Instead, he indicates that at that moment he's planning on issuing a warning to my client. And when he makes that decision at that point, that's when the trooper should be telling my client, "You're free to leave." The trooper has made a determination at that point. I'm unable to warn him. He needs to be telling my client he's free to leave at that point.
But if
The next trooper I'm sorry.
If the, let's say, standard operating procedure is to issue a written warning, then it changes the analysis, because then we begin to look at what's the time period that's reasonable for the trooper to write the warning, to record, for example, the make and model of the vehicle and the license, his license number and all of that. And if that is interrupted by the second trooper arriving and doing the canine check, you know, you've got such a short window here of time that it's very difficult, as I'm sure you know, to make the argument that the delay was unreasonable when we're talking about 4 minutes.
I understand in terms of making the stop and then the second car pulling up, and I totally understand that. And I think, I don't believe the testimony from the trooper was that he was going to write a written warning. My plan was to write a written warning. I don't believe that was his testimony. And
So we just don't know.
I don't. Yeah,
Whether
I
it's-
don't think we do know, Your Honors.
Okay.
To be fair. Your Honor, anyone else have a question? I thought someone may have had one.
No, I was just answering the question that Judge Moore.
Okay.
I should have kept my mouth shut.
Okay. How much time do I have, Your Honor?
You have 4.5 minutes, so you have a minute and a half before your rebuttal time.
Okay. Just reiterating the position. Officer makes a determination he should make this, that he's going to give a warning. He needs to articulate that my client's free to leave. Anything after that is a illegal seizure because the purpose of his stop is ended once he makes that determination.
Can you speak to, just in this
Yes,
minute
sure.
or so that you have, something that's not clear to me is the state makes this argument about the timing of your client's removal from the car relative to the canine hit. And apparently, I thought the state to say that your client was removed before before the canine hit. And you were saying that it was the other way around. Is that correct?
And I may have been mistaken in how I wrote the brief. I believe what took place, what the testimony was, the second trooper arrived. Again, after making the determination, he's going to write a warning. And speaking with the trooper, he tells the second trooper, I'm going to remove the defendant from the vehicle, put him in my vehicle so he can conduct a canine sniff. And that's when the first trooper moves to remove my client and put him into his vehicle. I believe that's the testimony, and I believe that's what I put in the report as well. And again, that's important because he had not yet been removed from the vehicle in regards to determining he was going to issue my client a warning. And I'll save the remaining time. And how much time do I have, Your Honor?
I'm sorry, you have like 2 minutes and 45 seconds.
Thank you, Your Honor.
Thank you.
May it please the court, Mr. Auberly, my name is Matt Kern. As you're probably sick of hearing by now, I represent, on behalf of Dean Holman, Medina County Prosecuting Attorney, I represent the state of Ohio. Really, I guess this case would boil down to the particular facts. And if the court finds that the trial court's statement of facts, as the trial court found them, are supported by competent and credible evidence, then it sounds like you will have no choice but to affirm. And specifically, I guess the critical issue is becoming whether the trooper was going to write Mr. Norvet a written warning or issue a verbal warning. And actually, by luck, we have a transcript of the sentencing proceedings, of the suppression hearing, sorry, and the trooper actually testifies as to what he was going to do. Transcript page bottom of 13, the state asks, and were you going to write him a ticket? Answer, at that point in time, no, I was not. Question, were you going to write him a warning? Answer, yes. Question, so you hadn't even left your vehicle to, and then the prosecutor changes tack and says, did you even start to write the warning yet? Answer, no, I was making the inquiry on my computer in reference to the driving record and the registration. So from the suppression hearing itself, we have testimony that the trooper was planning to write a written warning. And along that line, he was making inquiry on the mobile data terminal to ascertain the check for wants and warrants. During that time, before he could write the warning, Trooper Norman arrived pursuant to Trooper Hassler's request. So, and obviously Trooper Hassler had made the request while he was initiating the stop based on his observations of the furtive movements towards the passenger floorboard or glove compartment area.
Had made the request for the K-9 unit to
Yes.
back him up?
Right. It would be a very, very quick response for the Highway Patrol to show up within 4 minutes if that request had not already been previously made. Right? If the trooper finally, because he testifies that it took some time for the defendant to finally stop pulling over. He said that process was somewhat slow, and during that time the defendant was making the furtive movements. Once that stop finally occurs, if he calls in the plate and says, I'm at this mile marker, oh, by the way, can you send a K-9 unit to my location? It would probably take more than 4 minutes for the K-9 to respond. For the K-9 to arrive within 4 minutes of the initiation of the stop at the side of the road, that process is already in motion, most likely. Now, there's no testimony about that, but I think that's kind of common sense. So this argument on appeal, the defendant challenges the length and scope of his detention. But he's detained for the traffic violations, and while the trooper is still writing that written warning, the other trooper arrives, and pursuant to policy, the trooper testifies that they have a standard operating procedure to get drivers and passengers out of the vehicle to have the K-9 conduct its sniff. They get him out of the car, put him in the back of the trooper's vehicle, pat down for weapons, for officer safety reasons, and within 5 minutes of the sniff occurring, so 9 minutes after the stop, right, the dog arrives 4 minutes into the stop, the sniff happens within 5 minutes, so 9 minutes after the initiation of the traffic stop, Trooper Hassler is told by Trooper Norman that the dog, I believe it's Storm, had alerted to the odor of a controlled substance. And they have their roadside search.
I just wanted to ask you a question about the court's actual ruling and journal entry on this. And the court says, and let's see, 1, 2, 3, 4, 5, 6, 7. The beginning of the second page, I think like the 8th paragraph, first paragraph there on the second page, though. Trooper Hassler approached the car and identified the driver. Then he says, Hassler then advised why he stopped, and he was going to issue a citation. Then the court says he was removed from his car and placed into Trooper Hassler's vehicle as the citations were being prepared. Do you know what the court's talking about there?
So I think what the court is talking about there is it's generally consistent with the testimony that we've heard from the suppression hearing. That I think citation is maybe more generally is there's a written document being prepared. I think in terms of citation, that word might be technically incorrect, but the general intent behind the trooper told him that he was going to issue some kind of written documentation with respect to concluding the stop. I think that's generally correct, that he was removed from the car as the citation was being prepared. I mean, that is true, that he was removed while the trooper was still conducting the stop and had not yet written the written warning.
It makes it appear, though, that obviously, like you said, citation is more of a term of art, but even if you say that's a written warning, it makes it sound like the judge thought he removed him from the vehicle and put him in the back of the car while he was writing up his citation, as opposed to removing him from the car to conduct the dog sniff. Does that matter?
In this case, no, I don't believe it matters. I understand the court's concern, from an objective standpoint, could the court have written its factual findings in a more detailed manner that tracks with the trooper's testimony? Possibly. In this case, though, does that matter? No, because even if this court were to dig into the facts itself, there's only the one, as far as I recall, there's only the one witness who gives testimony, and that testimony is really not contradicted or impeached in terms of the sequence of events. There's really no dispute that there's a valid traffic stop, that the trooper was issuing a written warning. During the course of writing that written warning, he was running the defendant through the mobile data terminal for wants and warrants to run an NCIC check, right? And while that was still happening, the other trooper arrives with the dog. They get the defendant out of his car for the dog to do its sniff, and the dog gives a positive alert. And based on that positive alert, they do their roadside search. There's really no dispute about those critical facts as far as I understand Mr. Opperly's argument. So without any dispute over those essential facts, those are the facts for the court to find, and based off of those findings, the trial court's decision, i.e. denying the motion to suppress, stands. Those facts, it ineluctably follows that the trial court did not err in denying the motion, because if the sniff occurred during the time when the defendant was being properly detained for the traffic violation, and for the trooper to issue the written warning, then there's no extension, there's no prolonging of the stop, there's no expansion of the scope of the detention. He's still being detained for the traffic violation at that point. That's it. To the extent, though, that the court thinks that he was being detained, I would note that our brief also makes the argument that the defendant's furtive movements, the gestures that the trooper saw after pulling in behind him, after activating the overhead lights when the defendant reaches towards the passenger floorboard or glove compartment, and his immediate belief or suspicion that the defendant had some kind of weapon in the vehicle would, under Terry, give the trooper additional bases to prolong that stop. So the stop in the state's view was not prolonged. The scope of the detention was not exceeded. However, even if you think that the stop was prolonged, the trooper had reasonable suspicion to prolong the stop if he needed to either to wait for the dog to arrive, if the dog had taken longer, or for other reasons. So in this case, I understand the court's concern. I'm mindful of that, but I don't think it matters here. The court would reach the same conclusion in another way.
Was there any challenge, I can't recall in reading this case or another, to the actual hit? I know there's not a separate assignment of error, but was there any challenge that the dog actually hit?
No.
Okay.
And in fact, the facts actually kind of bear out why that is, because after the dog alerts and they conduct their roadside search, I think it's Trooper Hassler then returns to the car, and this is in transcript page 17 of the suppression hearing. He returns to the car and asks Norvet, I think he's already received Miranda warnings at this point, asks him if anyone had smoked marijuana or anything like that in the vehicle, and Norvet responds that someone may have smoked marijuana the previous Friday or Saturday.
Right.
So no, there's no challenge to the alert of the dog, and I think that's probably because we actually have record evidence that the dog's alert is not a false positive or otherwise subject to some kind of additional suspicion in some way.
Thank you.
For all of those reasons, the trooper is diligently conducting the traffic stop. He testifies that he was planning to write a written warning. He was fully within his authority to do that. The sniff is conducted before he finishes writing the warning. And as for the concern that somehow the trooper is in the process of writing the warning and then suddenly shifts tact to facilitate the dog sniff, well, if the dog has arrived and the dog is going to be doing the sniff, their standard operating procedure is to have people removed from the vehicles before the dog does that sniff. Getting the defendant out of his car, placing him in the back of the trooper's vehicle for officer safety reasons, patting him down, then I don't think we've changed the nature of the stop. He's still writing the warning, he's still doing all of those things, and that was his intent. We just have this brief sniff by the canine, which is fully supported by legal authority. So for all those reasons, I believe that this court has no basis to reverse and it should in fact affirm the decision of the trial court. Thank you.
Thank you, Your Honors. I'd like to, if I would, just speak briefly on Mr. Prosecutor's contention that even if you determine that the stop that was a detention, that the further movement's allowed for that, the officer, excuse me, the trooper had indicated some furtive moments in terms of reaching towards the glove compartment. But the officer approached the vehicle and then asked, and was able to survey, first of all, the vehicle in there, and then also asked my client why he did that, and my client gave him a reasonable answer, looking for his registration and to be able to get the paperwork to the officer. The officer doesn't indicate anything else in regards to those furtive movements. In fact, instead of, if there was a concern, as the prosecutor indicated, that the officer could have my client removed and then a pat down to search for weapons and make sure that for officer safety, never indicates anything about officer safety in his testimony. And so.
But the trial court said he did. Trial court said he was removed from the car due to officer safety.
I don't believe that there's testimony, again, I don't believe there's testimony from the trooper that says he was concerned for officer safety at the time, when he walked up and he had the conversation about, and then asked, and also asked, do you have anything illegal in the car? No, I don't. And the trooper then did not indicate that I was concerned for my safety. He instead said I was going to write a warning. If you're at all concerned about officer safety, you're not going to just write a warning to someone that you have pulled over there. So I understand where Mr. Prosecutor's going on that, but Mr. Kearns is going on that, but that's not what the testimony shows in regards to if this is determined to be a detention. Finally, this case is somewhat analogous to State v. Evans that this court had decided. And you have someone that's pulled over for a traffic violation at a gas station, and there's a determination that there's going to, I believe there's a determination, once they did the stop, they had determined the driver had valid registration and no outstanding warrants, and that's in State v. Evans. And the trial court determined the officer should have told the driver that she was free to leave, and therefore officers lacked any authority to detain the driver any further. And this court upheld that analysis from the trial court. I believe that that's somewhat analogous to this case, so I'd ask you to just take a look at that case. I believe I may be out of time.
You're out of time, so thank you very much.
Thank you, Your Honors.
Thank you both for your presentations to the court. The court will take the matter under advisement and issue a written opinion. That will be sent to both of you. Thank you.
Thank you, Your Honors.